In this episode you will see an 18-year-old faces assault charges against EMS personnel after a shocking hospital incident. Delirium, drug misuse, and a disoriented state collide, raising one big question: is this a medical emergency, or a criminal act? The courtroom is tense, the stakes are sky-high, and the jury has some tough decisions to make. You won't believe how far this case goes, and what could happen next. Stick around, because every twist will leave you questioning who's really at fault, and why the law draws such a fine line between compassion and accountability. If you want to catch every shocking detail and courtroom revelation, make sure to hit that subscribe button now so you don't miss a single moment of this insane legal drama.
Sir. In cause number 24CR1913, sir. Mr. Adams is here representing you, and you were charged with a third-degree felony of assault on EMS personnel, which, as you know, carries with it up to 10 years in prison if convicted. There is a recent report.
Whoa, up to 10 years in prison just for one incident with medical personnel? This is where the stakes explode. The court is not just weighing assault, it's about protecting people who are literally saving lives. And that's where the law draws a hard line: medical staff are off limits, no excuses. You start thinking, how much does the defendant's intent matter versus the outcome? That's the tricky part the jury will wrestle with.
Prepared by Dr. Edgar Kahn upon examining the defendant, and this is dated May 30th, 2025. It's also one dated May 21st, 2025. And these are similar based upon an evaluation on May 13th. And the defendant is declared competent by Dr. Edgar Kahn. I am calling these course exhibit number 1 in this court today's date. Any objections? No. This will be made a part of the record. Take your names. On May 30th, Dr. Edgar Kahn not only reaffirmed his earlier analysis of competence, but went into the issue of sanity or insanity. Did you think that's going to be the questions? I think he thinks out there is going to be a problem. Yeah. Fine. Right. But you got a copy of this May 30th report? I got this one. That's 21, yeah. And then Dr. Kahn went on to pick up the issue of sanity or insanity on his 30th day report. We got this. Some competing issues is that the defendant is brought to the hospital with what is reported as a drug overdose in an attempted suicide. And he wakes from sedation and disorganized.
Here's where it gets complicated. The defendant wakes up from sedation in total disorientation and ends up attacking the nurse. The medical term? Delirium, a real, diagnosable state of confusion. But here's the twist: delirium from the defendant's voluntary drug misuse does not automatically excuse his behavior under the law. The judge now faces a high-stakes question: was this a medical crisis, or a criminal act in disguise?
Disoriented state, and attempted to remove the breathing tube, kicked the nurse who was trying to assist him, which is, I think, where the assault occurred.
Yes, sir.
His version is the defendant states he doesn't remember. This diagnosis is delirium, which is now long resolved. Now, delirium in psychoanalysis is a state of mental confusion and reduced awareness characterized by sudden onset of symptoms consistent with confusion, disorientation, and difficulty thinking clearly. It is a serious but treatable condition characterized by sudden change of mental state, including confusion, disorientation, and reduced awareness. Any delirium is a serious disturbance in mental ability that results in confused thinking and reduced awareness of one's surroundings. And it is obvious in this case, the man was suffering from an obvious delirium. He goes on to state that the determination of sanity or insanity is the province of the trier of fact. And the problem we have here is we got some competing interests. He's suffering under what Dr. Edgar Pond calls confusion, delirium, but it's from overdose of drugs, which is not an excuse. You can't overdose on drugs and then start claiming defenses. So
it sounds like he's
fact finder to make a decision on these competing interests. But I think everybody would see, can see if somebody is misusing.
This is a classic courtroom showdown between empathy and accountability. On one hand, the defendant is clearly in distress. On the other, medical personnel have to be protected. The judge is essentially telling the jury, you decide where responsibility lies. And that's the tension that will keep viewers on edge, because there's no easy answer here.
Drugs, and then is being treated and starts beating up the medical personnel. We got problems. Medical personnel to be protected, and there is the issue of the patient, if they are in a reasonable state of mental awareness. But if they are not, because of their volitional misuse of drugs, that's not a defense. That's for, I guess, a fact finder to listen and weigh and make a decision open. But you can't say I'm going to misuse drugs and then later harm personnel who are trying to treat you.
So
if that were allowed, I think most people would say who show up to treat or to take care of someone, and then they find out that this is a misuse of drugs, then why would they want to put themselves in harm's way? Because they can be harmed, and then there's no accountability for it. That's not, well, that it does not seem to be a social standard that we want to go down. Yeah, people need to be treated when they're not well, but the treating authorities should not be left without any type of defense under law. And otherwise, people are going, the ambulance aren't going to start showing up at locations if they find out that it's drug overdose. It'll get out pretty quick. But they've got other things to do that are more important than self-harm. So that's what it states. And it's fact is for the fact finder. You want to go to the judge or the jury, that's your call, but it's a possible defense that can be raised, but it's not for, it's for the fact finder to decide, and he's competent otherwise. So set it for trial.
But have you been able to talk to him about the offer, or?
I have.
Okay.
Yeah, I've given him the offer. The last offer we got was a cap of 8 years. I did get that to him, and
All right. You told it to him. It's his decision. It's set for trial, and we'll let a jury roll it out. And
He has a lengthy criminal history and is not probation eligible.
all right, anything else? You understand where we are, sir?
And just like that, it's set for trial. But notice this, the defendant has a lengthy criminal record and is not probation eligible. That raises the stakes even higher. The jury won't just look at this one incident, they'll weigh a pattern of behavior. For viewers, this is a textbook example of how prior history can shadow even one isolated case. You have to ask yourself, will the jury focus on this single overdose episode, or the bigger picture?
Yes, the
Okay.
attorney said, yes.
Anything else you want to add, sir? No, just
My trial attorney was not notified that this was happening today, and I'm trying to get my attorney to call my trial attorney, my caretaker, to be here. I have traumatic brain injury and seizures. I've been in the hospital all day yesterday and tonight, and I was missing this court date last time because of having seizures in the hospital. But I need my caretaker here.
We'll subpoena those records.
okay. Anything else? This is set for trial. Thank you. Next is,
Thank you.
yes, sir.